that's going to be, I think, even easier.
All right, just don't make any laws while you're sitting up here.
Oh, wait, there's nothing. Yeah. So, John, just make sure you push it a little back.
That's fine. That's great.
We can share. Awesome. All right. There's one more lease if anybody wants. Okay, go ahead, John. And tell us a little bit about yourself and what you're going to talk about.
Sure. Good evening. Thanks to everyone for being here, and I appreciate Councilman Means putting this on. My name is Jonathan Kamen. I'm a lawyer here in Pittsburgh with Goldberg, Kamen, and Garvin. I am a zoning, land use lawyer, primarily concentrated in real estate, and do a lot of real estate-related litigation. Along with my colleague John Smith, we represented the 7 plaintiffs who challenged Act 13 as an unconstitutional overreach by the legislative and executive, and I'm pleased to inform you we were successful in our challenge. There are lots of things that we could talk about with Act 13, but I really want to focus on the issue before us here today, because I think that's helpful. And as a government and as a community where we live, I think what we do now is important for not only for us, but for generations to come. And that's not necessarily me who only agrees with that. That also happens to be the Chief Justice of the Pennsylvania Supreme Court. And as far as what we do, we are not anti-development, we are not anti-anything. What we're looking for is safe and responsible practices. I'd ask John if you could go forward to our first picture. The question that I think you have to ask as an owner of the park, and the question that you have to ask as a fiduciary of the county's resources and the Commonwealth's resources is this compatible with residential zoning? Is this compatible with park use? Is this compatible with the highest and best use of our county property? Now, I would tell you that this picture is not something that we got off of Google or stock images or anything like this. This picture was actually taken by a client of ours of a site. I believe that one's in Washington, right, John?
That's actually, it's in Robinson Township, the namesake of the case.
Right, so that's in Robinson Township, Washington County. So that's your neighbor to the south and our neighbor to the south. And the heart of what we fought for in Act 13 was that local government ought to have the right to control the land use that happens within their borders. In addition to that, we fought for the fundamental constitutional principle of zoning, which is compatible uses belong together. If the proverbial pig doesn't belong in the parlor, the pig belongs in the barnyard. And if anybody can sit here and tell me that this is not an industrial use that would belong in an industrial area, I would challenge them to take their kids out here and see if they wanted to go play on it. It seems to me that the question of is there a place and what works and what makes sense is a question that is right for good people to debate. It's a question that is right for municipal governments and executives to debate. But the question of, does this belong in your park as a park landowner and as our representatives, I think you have the obligation to say, well, not only what does zoning justify, but what do I as the landowner think is right? And one of the things that I want to emphasize, John and I could talk about our Act 13 case. We've been talking about it for 2 years now as we've gone up and down the courts. We're relitigating portions of it in 2 weeks in Commonwealth Court in Harrisburg, or in Philadelphia actually. But one of the things that I want to talk about, and John, if you can go to the last slide if possible.
Keep going.
Well, let me just say, this is a impoundment. Now, the lease that you have does not provide for impoundments. I think it says that there won't be impoundments. But that doesn't mean that this water isn't somewhere else, right? That doesn't mean that this water isn't on your neighbor's property or on somebody else's neighbor's property. The 15 million gallons that the professor talked about before, well, that's got to go somewhere. So, while it may not be in your park, you know, there's no miraculous mortar that starts at the ground and goes to the ceiling that stops everything from traversing.
And I'm not going to stand up and
Go ahead.
interrupt you, John, but since Dr. Stoltz is here, one thing I was going to ask him, and I think he'll attest to, is when you hear about water being recycled, typically we think of recycled things as good, as environmentally friendly. Recycled water is the most hazardous water in this industry because once it's used, and once it goes down whole, once it's mixed with the chemicals, it comes back up whole, it brings with it all the different things that Dr. Stoltz talked about. Then it's reused. Then it goes through the process again and again and again and again. There may be fresh water added to it or different water added to it along the way, but recycled water is one of the biggest problems because of the number of different chemicals. And what's also needs to be understood is that these impoundments regularly get treated with biocides, they get treated with other chemicals. So those chemicals, you may have 7 or 8 different drill sites of water being used to frack under the park. So it's not pristine water with the first time chemical being used. So you need to understand that that's how it works. So when, I know Dr. Stoltz, I'm not sure if your studies actually looked at how many different times it came back and forth. But I know that from the practice because when you 100% recycle your water, it doesn't go through a cleaning process. It just goes back into these same impoundments to be reused, just more chemicals be added later.
Right. So if you ask yourself, I think the number is about somewhere between 40 and 60% of the water gets recycled. Well, recycle just means reuse, right? It doesn't mean clean. John, where is this one located? This is also in Washington County?
I believe so, yes.
Yeah. Again, this isn't something we got off stock images. This is something that one of our clients actually took the picture of. This is a flaring, but you know, I actually happened to see the one at the mills. It looks different in person.
You want me to keep going?
Yeah, I want to get to the end, to the Supreme Court decision. We back up, John. Just want to click on the last slide. So one of the things, in our case in the Commonwealth Court, what the Commonwealth Court said was that the fact that they had removed the zoning rights from the locals and the fact that the state had authorized this to happen was a violation of substantive due process. And the reason why is because it removed the locals' ability to determine what is compatible and impose that from the state level without regards to local neighborhood characteristics, without regard to local sensitive receptors, so streams, wetlands, schools, other things that people care about. And they said that that decision is fundamentally a local issue. John, can you go back one slide? Yeah, this is what I was looking for. Thanks. The couple things that you need to think about. Let me actually go back one more and then we'll come to this one. So we took this case into Commonwealth Court. We won on the substantive due process. In other words, they said what you're doing is irrational. When you put an industrial use into a residential area and you require that to be there, you have in fact destroyed the very character that the law was trying to create. The Supreme Court came at it in a little bit of a different way, and everyone says, well, it's a plurality decision. No, you know what? It's the law of the Commonwealth. Okay, it's yes, there were 3 who voted for it, but there was a 4th who joined, and the decision was 4-2. So more than anything else, it is the law of the Commonwealth. But I think Chief Justice Castile's words are very true and ring true to you as the stewards of this important asset. And his words were based on the Constitution, the Pennsylvania Constitution. And we all live under the Pennsylvania Constitution. And we have in Pennsylvania something called an Environmental Rights Amendment. And our position is that that means something. Just like the free speech amendment, the Pennsylvania free speech amendment means something, just like the due process amendments, just like anything else, the Constitution means something. And it can't be ignored for a specific industry. It can't be ignored for money. It can't be ignored for going ahead and creating jobs. It's the law. It's the law that we all voted on and accepted as members of this Commonwealth. And the first part of Article 27 says that the Constitution guarantees the people the right to clean air, pure water, and the preservation of the natural, scenic, historic, and aesthetic values of the environment. And when you are a county council person, and as the steward of that, in charge of the land that the county owns, you have to remember that this isn't just a decision of, do I like range, do I not like range? Do I like Huntley, do I not like Huntley? Or, would I rather have somebody who's here from the Center for Sustainable Shale who's going to operate at a higher level? The question is what is your constitutional obligation that you all swore to uphold when you took the oath of office? And the first thing to remember is Section 27 pretty clear says that this right is a right of the people to these things. Now, the other thing that Justice Castillo said, and again, he said it way better than I could, is that the Pennsylvania's natural resources are the common property of all of the people. And that includes generations yet to come. So when you think about what is it that I'm doing, you can't just think about, well, what is it that I'm doing in the next 5 years, right? And you saw the professor's shale curve, right? It comes up. Listen, I'm sure we could make a ton of money from this. There's nobody doubting the money side of it. But the question is what's your obligation? What is your legal constitutional obligation? And again, this isn't me telling you as an advocate. This is the Chief Justice telling you what the law is. And what, in his eyes and in my eyes, is that the obligation is to generations yet to come. So we better make sure that we know that the, 3 million gallons, 5 million gallons, whatever, take whatever million gallons you want, that we know that once it goes down the hole, it can migrate, it can go somewhere else. We need to understand what are the pathways that are there, what naturally exists, so that it ends up somehow in our groundwater, our surface waters, or in the rivers that we all go ahead and drink from. So it's important that we also think that, water by its very nature is not static. Water moves. So it's not like you can just put it down in the ground in the strata and it's going to stay there forever. At some point, it's going to go somewhere. And we have to think about it again, not just short term, but long term. And the last part of the opinion that I wanted to highlight for you, at least in this little part, is that your duty as an official is a duty as a trustee of the resources. And again, this comes from the Constitution. Section 27 has a double part. There's a fiduciary obligation, which is a trustee obligation, and there's also a restraint obligation. And that's the obligation from, according to Justice Castillo and according to the Constitution, is to conserve and maintain these resources for the benefit of all the people. So what does conserve and maintain the resources mean? In my mind, that means protect them. You protect them in the best way that you can. And you have to ask yourself if I'm allowing this drilling in the park, am I going ahead and adhering to my constitutional duty to conserve and maintain them for the benefit of all the people, including generations yet to come? And Justice Castillo also said is that there's an affirmative obligation of the government. So it's not just passive, but it is your obligation as steward of the parks, as sworn elected officials. It is your obligation to make sure that you have refrained from unduly infringing upon or violating these rights. These are like the free speech rights, right? Violating these rights, including by legislative enactment or executive action. So what that tells you is that we're just temporary people here occupying some space, thankfully from God, between now and the time that we die. But the Constitution is the framework that governs everything that we do. And what Justice Castillo is saying is that it's larger than any of us, these obligations. We're here as stewards, but it's larger and more powerful than the legislature, it's larger and more powerful than the executive, and it is our compact that makes us special. And in order to adhere to that compact, we have to make sure as the trustee and the fiduciary of these resources that we've done all of our homework and all of our due diligence. And, you know, whether you're for drilling or anti-drilling or whatever it is, there's no excuse for not doing your due diligence. And I'm not sitting here telling you that I think a ban is legal. I'm not sitting here and telling you that I think it should be everywhere. What I'm saying is that I don't even know that we know enough to give a coherent answer, because there has not been due diligence done, and that's not necessarily just on this particular site, but I think there's a lot of stuff that we don't even know. I mean, as you heard from Duquesne University, we're studying the water. We don't even know what's in it. This has all happened so fast. And as you look back, and I would encourage anyone who has some time to read Justice Castile's opinion, but he goes through painstakingly the history of the Commonwealth. We have been through a massive, massive change from the beginning of the Industrial Revolution. And Pennsylvania was the center of steel, it was the center of coal, it was the center of all these resources, and at the time, everybody thought it was great. And everybody was looking to do whatever we could to make some money, to provide jobs, to do all the right things. But you know, as you look back on it, you think, well, I don't know that anybody thought at the time we were going to have orange water or acid mine drainage, or that we were going to have bad air, or that we would have heavy metals in a higher concentration than almost anywhere in the country. I don't know that anybody thought that, but it just seems to me that a lot of this is happening really fast. And like I said, good, bad, or indifferent, you have an obligation, and it's not me saying this, it's the Pennsylvania Constitution saying this, to do your due diligence. So I can talk forever, as you may imagine, about any aspect of Act 13. I do want to turn it over to my colleague, John Smith, who is, in my mind, one of the greatest patriots that this Commonwealth has, because single-handedly he has worked to make sure that, you know, we have something here in Pennsylvania to protect. So,
Well, thank you, John, for that. So, with the case right now, I'm going to leave it at Act 13. We'll go into some of the due diligence issues. Well, what's left in the case before the Commonwealth Court that the Supreme Court remanded back down are four things. One is the role of the PUC, the Pennsylvania Utility Commission, to review local ordinances. Second is the medical gag provision. So whether doctors can tell their patients and or share information about what people may have been exposed to. Then we have the eminent domain issue, whether private companies, the state law has given the industry eminent domain powers to take from Pennsylvania citizens if they need storage fields. John's going to be arguing that is unconstitutional. And then lastly, there is a water issue that's being argued. In the Act 13, there's a provision that provided that if there is a spill, there is an absolute obligation on the part of the DEP to notify the public drinking water source. No mention if there's a spill to notify people on private drinking water. If Dr. Stoltz had his slide back up, you will notice the majority of drilling in Pennsylvania is done in areas where people utilize private drinking water sources. So it's an equal protection claim that you're treating people differently, and those are the four issues that are back on appeal that we will be arguing in a few weeks. In the Supreme Court opinion, it's quite a lengthy opinion. It's a landmark decision by all accounts. I recently spoke at Yale Law School on the issue in the last month or so, and the professors around the country said they believe it's the biggest environmental decision ever in the United States. These are law school professors, that's how they see this opinion. So the opinion means something nationwide, it should mean something locally. And John very eloquently explained that when you read the opinion, the court walks you through how we have used and misused the environment. And the court basically talks about the genesis of Article 1, Section 27 of our Pennsylvania Constitution. It came about to stop these practices and to make public officials be stewards of public land. So you're not a typical leaseholder. You are not a client of mine who comes in and owns a farm, because you stand in the shoes of all your residents. The individual leaseholder stands in their shoes of them and their family. They don't have constitutional obligations to look to. You do, as a board. So what does that look like? The court talks about doing your due diligence, and the court talks about making sure you provide clean air and pure water for future generations. So how do you do that? So the question is, what do you know? Do you know all the chemicals that are going to be used on this site, on any of the drilling sites? I'll tell you your answer is no. Do you know the location of the sites? I think Councilman Means asked the question. The answer is no. Without knowing that, how do you know whether your park is at risk or not? How do you know how far the emissions will travel from a given site when you don't know where that site is? How do you know the hydrogeology of the area? So if there is a leak or a spill, whether it will affect your park when you don't know where the site is, where you don't know the hydrogeology, where you don't know the chemicals to even look for to test where they might show up in your water. In the opinion, the court cites back in Franklin Curry, the author of Article 1, Section 27, is alive and well. He was a state rep, he's an attorney, and I believe John in Harrisburg now. And they cite him a lot in the actual opinion. And the court cites to this provision, says the proper exercise of the trustee's discretion is measured by benefits bestowed upon all the Commonwealth citizens in their utilization of natural resources, rather than by the balance sheet profits and appreciation the trustee realizes from its resource operations. The court is not worried about the economic realities of making money. There's no constitutional amendment about making money. The constitutional duties you have is to make sure in the process of making money, you're not giving up any environmental protections so that future generations have the same exact park you have now. So when you look at these issues, when you ask the questions, and I don't believe the questions were asked, and I watched some of your council meetings, what kind of emissions come off these sites? These drilling companies have to file an emissions inventory with the DEP on a yearly basis. So they know. They know there's certain VTEXs, benzene, toluene, xylenes coming off these sites. How far will they travel is the next question. One of the reasons the court struck down Act 13 because there was a mandatory 300 feet from a well pad that drilling was allowed in Pennsylvania from every home in the Commonwealth, 300 feet away. And what we said is, how in the world, as a local governmental official, can we allow such a use when you're not taking into consideration the local issues? What are the wind conditions where they're going to drill? How far will the emissions travel? And again, it depends on a lot of features. It depends on topography. It depends on the valley, the location. It depends on what stage of drilling they're in. You also have issues with truck traffic. You have issues with noise. Some of these may be taken care of by the local municipality if and when, because of Act 13, the local municipality now has the opportunity to review the drilling operations that go into that municipality. Had we lost, it would have been permitted. There would have been no recourse. So now the municipality for which this operation will take place does have the opportunity to even further look at this. But you're in a unique situation because you don't have to rely on the fact of whether or not that local government's going to do its job. You have the ability, and it's kind of a dual ability. You're looking from a contractual situation to enter into a good lease that serves to make you money and to protect you. But you also have the ability and the obligation to make sure that you protect the park in the process. And when you ask yourself those questions, that's why when I've talked to some councilmen, have you done a hydrogeological study? So when there is a spill or leak, what will be affected? Have you done air modeling? The science exists for you to determine what will be the potential impacts. So then when you know the potential impacts, I'm not telling you which way to vote, but when you know the potential impacts, at least it's an informed decision. So if you get called to court someday and said, did you do your constitutional obligation? Did you do your due diligence? And I question you and I ask you the question, what were the chemicals that they used? And your answer is, I don't know. Well, when you approved this, did you know where the drill sites were? Well, no. Did you know the air conditions or the air modeling? No, I didn't. What was the hydrogeologic conditions? I mean, we're talking about park and park water. I don't know. So when you answer those questions in the negative, how do you then, to your citizens, answer in the positive that this is the way to go and that we have fulfilled our constitutional obligations? Now, I did go through your lease, and I'm not going to go through it painstakingly, and I'll answer questions as they come up, but I did have some questions about Section 8, which is your groundwater section. I'm sorry, I
Page 13, and then we're at page 11.
think it may be renumbered in your document. It's under water. It's under water quality.
Okay, 8. Okay, page 11.
So what struck me, having dealt with these issues before, is remember, drilling doesn't not only may affect the water quality, but the quantity of the water as well. So how much flow? People lose their water supply quite often from drilling because when you're underground and you're moving things around, it may change the way water flows. Water quantity is not mentioned in your lease at all. So if the lake starts to drop in terms of depth or in terms of the stream or the flow, you haven't even planned for that. You haven't even considered that in your lease. You talk about water quality, not just quantity. You also talk in here about, in the first sentence, the lessee's operations, the drilling company, in the units of which the lease premises are a part of, are a part of the whole, shall not materially and adversely affect the surface waters located in the park. The words materially and adversely affect are worse than the state law. The state law basically says you shouldn't impact our water, you shouldn't cause any pollution. In my reading of this, you've created and given them a higher standard that they can, until they materially affect your water, they don't have to deal with it. The state law is actually more protective than your lease. When you look at the second part of it, there's a whole section about the presumption that if there's a spill, there's a leak, and it goes on at great length, I mean almost a page about how if the pollution existed prior to drilling, this whole idea of if they do find anything in these water tests, that there's a presumption that they caused it if they're within so many feet.
Where is that?
If you look at, it's in actually 8.01.2.
Okay.
So in the event of a determination made about the quality of public or private water supplies, landowner water purveyors, it goes on, and if you read through that paragraph, it talks at great length, and this really mimics Pennsylvania law. So these lease terms were not anything that were placed in here that are different than what other people have. You could have made them different, but they're not different, and I'll get to that at the end here. When you read to the end about all this presumption, it says it only applies, by the way, to drinking water sources in the park. Well, your park doesn't have drinking water sources. Your park has lakes and streams and springs. So when you read it again, by the way, shall mean only such water supplies used for domestic consumption. So this whole paragraph doesn't even apply to you. And you could have made it apply to you. You could have said, by the way, this presumption will apply to non-domestic water sources because the state law only allows it to apply to drinking water sources. But since we're drafting this being more protective, we're going to make that presumption apply to our lakes and our waters. In this paragraph as well, you talk about surface waters. There's no mention of groundwater. Well, surface water, we understand that as lakes and those are things you see, but you oftentimes will have contamination of the groundwater. It's not until later in the lease you even see the mention of groundwater for the first time. Because, and so this is what you and I've talked about, once you know the hydrogeology, once you know the location, once you know the chemicals, then do you put ground well monitors in place? And that way, that is testing the groundwater before it ever gets to your park. But you need to know what to look for. And again, under Pennsylvania law right now, if there is a spill or release, there's no obligation to tell you. So the obligation should be that this is what we spilled, these are the chemicals, you may want to make sure it hasn't reached you yet. So those are some of the best practices that could exist. And I think the question was asked to the operator, will you be installing ground well monitors? And I think the answer was, we're not sure. So,
I think it was no.
but again, it only makes sense to the extent you know what to look for, you know there's a spill or a release, and again, you're checking the groundwater. I imagine, I don't know the park, but I imagine the park is spring fed. It comes from some groundwater source. Where does that source begin or end? Where is the aquifer that could be affected? And I ask that rhetorically because, again, as part of what I believe, and John believes, as part of council's obligation under the Constitution is to know these answers. The reason I think a lot of these people are here is that in opposition is they feel that these answers, number one, I don't think they think can be answered, and number two, they haven't been answered. So I don't want to go through all through your lease, but obviously from a water standpoint, knowing a little bit about it, having dealt with cases on water impacts, it struck me that your lease was less protective than state law. So, but I'll answer any questions you have.
Yeah, go ahead, Bill.
Thank you, Madam Chair. Again, let me thank you for being diligent in informing yourself and our colleagues. I had the honor of serving in the Pennsylvania General Assembly for 14 years, so I have some familiarity with the state constitution and its importance. I want to thank you gentlemen for reassuring me that this does relate to black people. We are people in this Commonwealth. We deserve to be protected as well as anyone else. We also deserve to be informed. I can appreciate now why you gentlemen were not allowed to present some time ago. When I first started on my journey to determine whether or not I should support what the county administration wanted to do, I made it clear if they could convince me that over a 10-year period, some kind of business relationship could produce $50 million a year, $500 million, I would be more inclined to support what they wanted to do. I said that simply taking an economic position because I believe that's the kind of money that this county needs over the next 10 years to avoid a tax increase and also do the things that my colleagues and I would like to do. Most people told me, no way in the world can $500 million be created over 10 years. And I must admit, I came up with a figure that I did not think the administration in cooperation with any corporation could produce. Boy, was I right. Not even close. I still maintain that. If they could show me how they can produce $500 million over the next 10 years, I'm more inclined to support what they'd like to do. But having been informed, including tonight, I don't necessarily have questions. I have concerns about when I'm not here. The fiduciary responsibility, trustee responsibility, etc. And I think without proper information, even my colleagues who believe this is the right thing to do are leaving themselves vulnerable. Vulnerable in a way that they cannot be protected politically. I learned in the legislature you can sit there and not pay attention and vote any way you please. I used to sit there reading the newspaper, and leadership would come over to me and say, you know we're on television. I said, yeah, I know we're on television. People call me, they see me sitting there reading the newspaper. They say, aren't you concerned? I said, no, I'm not concerned. They said, why not? I said, because I'm going to vote the way you vote. Then they walked away. I was listening, I was saying, I had made a decision to follow leadership. Leadership is very important. Unfortunately, I think the leadership of this council has not made its responsibility to fully inform us and then let people vote any way they choose. They don't have to believe anything, but they need to have information available in case, just in case, you end up in a courtroom or end up in jail or end up trying to figure out what a judge or judges have said in an opinion. I advised my colleagues almost as soon as I got here, stay out of the courtroom and stay out of jail. I have suggested to them recently, stay out of the courtroom, stay out of jail, and be careful when you start analyzing, criticizing, and complaining about a judge's decision. That's good advice. Let me just say a couple other things and then I will end. I have looked for venues in which I can share this kind of information. I think, unfortunately, and to the detriment of this council, our leadership, with the aid of the Fitzgerald administration, has prevented us from being informed. I don't believe that what these gentlemen are presenting tonight is going to change anybody's opinion about how they're going to vote. But like I said, stay out of the courtroom, stay out of jail, and stay out of situations where you have to try to figure out what a judge's decision means. At the very outset of this discussion, I filed a right-to-know request with the Fitzgerald administration. I didn't share what I had done with my colleagues. That was my personal business. And I asked for various documents. I was denied. In the face of Mr. Fitzgerald saying he wanted to work with us and all of us could be involved. Today I made that right-to-know request public to the media and to my colleagues. And Mr. Fitzgerald, through his staff's response, stay out of the courtroom, stay out of jail, and stay out of situations where you have to try to interpret what a judge is saying. I anticipate sitting on my porch at 3110 Avalon Street when this thing blows up, sipping a gin and tonic. I've been an elected official for 35 years. And one thing I've learned, get as much information as you can. Make your decision after you get the information, even if you already made your decision. You need to have rationale. From what I can tell, there are at least 10 reasons to be for what the Fitzgerald administration would like to do, and 10 reasons to be against it. And people are going to vote accordingly. Find a rationale, stick to it, know about it, go to your porch or join me for a gin and tonic. I thank my colleagues, the two who are here, for their diligence and their patience during this process. Mrs. Means is new. Mrs. Ray has been here for a few years. But I think they both exhibit an appreciation for the downside of being an elected official, and that is to listen to presentations, to stay half the night, and to appear to be interested. And I thank them for doing that. It'll serve them well as they continue to serve to this county. Lastly, I like to ask my black questions, if I might, just two. Are there any black lawyers in this Commonwealth that you're aware of to either have the expertise, the guts, the gumption, what have you, in this regard, or is this an area where people who look like me just didn't get it, or don't get it, or just not involved?
One thing I will tell you, sir, is that there is an African-American lawyer who's worked with us on this case, who continues to work with us on this case. He is not from the Commonwealth, he's from Ohio, and I will provide you his name in confidence after this presentation, and he will be glad, I'm sure, to speak to you. In fact, anytime he sees this in the paper, this issue, I get an email about it. Your second question, though, we anticipate that sometimes contaminated water does not discriminate. Whoever's living in the house that may be using the water, I have African-American clients whose water has been impacted from drilling operations.
I appreciate your concern. Let me just say one other thing, and then I'll be quiet for the rest of the night. I think it is very important for those who are here to take serious what Ms. Means, in particular, has been bold and courageous enough to do. If indeed this council chooses to pass the legislation that Mr. Fitzgerald is touting, we will do two things other than have changed the process since I've known it since 2004. We will have, for the first time, considered a lease agreement that is not before us legally. We've never, ever had a tentative lease agreement presented to us for our consideration. That's one thing we will have done. We'll change the process, and we have opened up the door that every single lease in this county needs to come before county council. Yes, including the lease for the lady that sells ice balls somewhere else at one of our parks would have. That's what I think we ought to do. We ought to have every single lease. That's me talking. Lastly, when I was a kid, I used to go to the segregated South Park. Swim in a pool where only black people were allowed to swim. Because the white people didn't want us up on Corrigan Drive, so we went to Sully's pool. It was called the Ink Well. We even called it the Ink Well. What an insult to ourselves. First, Deer Lakes. Next, North Park. And then, you know where we're going. We're going to South Park. If we're going to find $500 million, and I believe that's what we need, we have to drill under every single park in this county. If this passes with this procedure, this is what you're going to see in the future. This process being shoved down our throats by this administration or a subsequent administration. Thank you, gentlemen, for your diligence. Thank you for not being intimidated. Thank you for understanding that somebody had to tell us about the law to keep us out of the courtroom, keep us out of jail, and keep us from getting all tangled up with some judge's decision. Thank you very much.
Councilman, I did want to add one thing as response to your question. And John hit on it a little bit, but I know your district. I know where you live. I have friends in your district. And I happen to drink the same water that you drink in your district. So from the standpoint of when you say, how does it impacts everybody. And the other issue that comes with it is, thankfully, I'm in a position where if it gets bad enough, I'm happy to leave the Commonwealth. I'm happy to leave and to go. And have the ability to do that. A lot of people don't have that ability. And I don't think the choice should be, do we do something and then have people leave town? Or do we do the right thing and make it so everybody can stay and have their own values and have everything the way that we know it and like it? So from the standpoint of the Constitution affects us all. The obligation is an obligation for you as public officials, but also you as stewards of the county assets and the county parks to take care of. And I think that it is, you're right, a game changer the way that it has been presented. And John and I appreciate you guys having us here. And as I said, this is one other thing I would say is this is not a Democratic Republican issue. If you look at the way that the Commonwealth Court decision came down, that was 2 Democrats, 2 Republicans found in favor of the law being unconstitutional. If you look at the way that the decision was in the Supreme Court, that was a bipartisan decision written by the Chief Justice, who happens to be a Republican.
And
So-
our clients in Act 13, majority were Republican.
And the majority of our clients are Republicans. But the thing that unites everybody is the constitutional obligation, the fiduciary obligation, and the fact that you as elected officials have to take your trustee and stewardship seriously. So we appreciate you having us here.
Anything else?
Thank you, Ms. Means. I have a question about this section, the water quality section in our lease. And what you are saying, or what I think I'm understanding you're saying, is that in that 8.01-1, that it's a lesser standard than the state has. How could that possibly be?
You don't see the words in state law that your water gets replaced or addressed if it's materially and adversely affected. Usually if pollution reaches your water or if your water is impacted, those are the words. So the way I read those words is materially and adversely affected is a higher standard, that we can have a little contamination, but until we materially and adversely affect your water, it's a different story. And the state law doesn't read that way.
So if you were representing a client leasing land, you would say this has to be changed.
Well, I would say, why would we draft something in a lease that gives us less protected than the state law?
Yeah, that's what I guess I'm just
Well, I'm sure others will tell you they disagree and they think it's the same, or or less, but in my opinion, and probably John's opinion, materially and adversely affected versus if your water is impacted and or if we find pollution in your water, doesn't seem to have a certain level, and that to me sets a level.
And you're saying that also this is lacking quantity, and you're talking about the lake, that there's.
Well, any of the water, when some of my clients have lost water, the water is not only impacted by the chemicals or contaminated by the process, they may lose their well altogether because just the alteration of the ground. So there's a water, and state law speaks to this too. State law speaks to water quantity and quality. Your lease speaks to quality, doesn't mention quantity.
Okay. Now, why do you think that's left out of our lease? I mean, you can.
Now, maybe, and I don't know why you would put quality in and leave quantity out, because oftentimes we will leave things out of leases and say, well, state law already speaks to that. But state law already spoke to the quality part of it as well. So I'm not sure, why open the door to an argument that we don't have to replace quantity, because it turns out the spring that was feeding your lake somehow underground got shifted and it's going a different direction and your lake's falling. Now, I'm not saying that that is even possible, but that's why quantity and quality exist in Pennsylvania law.
Okay. I guess I have one more question about the water, and that's the next section. And just trying to make sure I understand what you said.
On the presumption?
Yeah, the state law. You're saying this is what's.
This pretty much mimics state law. The distance in here may be a little bit greater. So is it 3,000 or 2,500 from a 25 from a well site? There's a presumption that if there's any impact in your water, so if we find we do a pre-drill test for your water, and let's say that there's no boron in it, and then we come back after drilling within 12 months and we find boron, this will, and so will Pennsylvania law, presume that they caused it. So now the burden is shifted to the industry to say that they didn't cause it, but you don't have to establish that under the law they caused it. Because the presumption was it wasn't there before, we're in that certain distance. I think the distance is greater than state law requires.
Okay.
But when you get to the end of it, you are not a homeowner protecting your domestic drinking water source. You are a county protecting your lakes and streams, and it specifically says this doesn't apply to you. It only applies to domestic drinking water sources.
So it doesn't apply to any of the lakes and streams
No.
in the park. So that's left.
What I would have done, when I read this, I said, well, this is great, before I got to the end.
And then,
Because they built in and drafted in state law and went further and said, we're going to make it apply to all your water sources. Then they didn't. They went back to the state standard of drinking water. And I don't believe you have any drinking water sources in your park. So it just takes up space on your page. Doesn't mean anything.
okay, and then may I have another question?
Oh, go right
Okay, either one can answer. We had our county solicitor here, and he kept talking about a plurality decision, like that was not.
We get that a lot.
Yeah, and that's
Well, no.
curious to me because I'm understanding the Chief Justice wrote the decisions. From what you are saying now, it's an absolute.
Well, John can speak to this. I'll give you my opinion on it. I believe, number one, there was a majority decision 4-2 to strike down the law.
Yes.
3 of the justices used Article 1, Section 27. 1 of the justices used Article 1, Section 1. So you do not have a majority opinion as to why it was unconstitutional. That's why it's called a plurality.
Okay.
This council has no other law to look to. You have no other decision to look to. When the highest court in this Commonwealth has addressed the issue, this is their opinion on it. It is a plurality. It is not a majority. So at the very least, it's the only instructive opinion that you have where a court has weighed in on this issue. You don't ignore it. It's instructive. But I think I told other council members, let's assume there was no opinion. Every person pretty much behind me in this room has always argued that Article 1, Section 27 applied anyway. So you don't need a Supreme Court to tell you what your constitutional obligation is. The opinion doesn't even exist. The Constitution still exists, and there's only one court who has interpreted your rights, and that's the Supreme Court.
Yeah, and I would add, too, that you owe it to yourself to read the decision, because it is eloquent, it is thoughtful, and it is really, I think, a wonderful wake-up call as to what does the Constitution mean. in what is your obligation as an elected official. Because keep in mind, what he was saying in this opinion, and I also want to remind everyone, we won 4-3 at the Commonwealth Court. They threw the same law out as unconstitutional, albeit on other grounds, because they had the same concerns.
And there's a majority opinion.
And that was a majority opinion, 4-3. And also, Justice Baer, in his dissent, states that he agrees with his concurring opinion. He agrees with the rationale of the Commonwealth Court. So if you look at it and you say, well, what have our appellate jurists said? Both courts that have looked at this have said it to be unconstitutional. And as Councilman Robinson will tell you, it's nearly impossible to get something thrown out as unconstitutional. I mean, if you would have talked to our colleagues, and John and I spent a lot of time with our colleagues in the municipal world and land use world, and they gave us about a 5% chance of success. And to go ahead and have a law declared as unconstitutional is a miraculous feat in itself. So what I would say, though, about Justice Castile's decision, which is the words mean something, and it means something to you as an elected official. As John said, even if you didn't have an opinion, it means that you have this obligation as a trustee and a fiduciary, particularly when you're talking about a public asset. So I would say that I would think very carefully about, have I done my due diligence to make sure that I'm upholding my constitutional duties.
So if nothing else, it's at least instructive to council. You have no other contrary highest court in Pennsylvania telling you any different. You have an instructive opinion as to what your obligations are. As I said, most of the people in this room would have told you that was your obligation whether the court spoke or not.
Okay, thank you both.
Yes, Ms. Mead, do you have any questions?
I do. So do you think if we don't see the RFP and the Range Resources response to that RFP, do you feel that we have done our due diligence if we haven't seen that document?
Well, with any RFP, when you get a request for proposal and you ask for specific information, I don't know how your county system is set up, and maybe John can speak to this better than I, but as to the powers of your executive versus the power of the council to look at that information. I will say you need to make sure the information was provided. If that information was so critical in the proposal, then I'm not sure how county council makes a decision that for information that we requested to help us make a decision, but the decision makers can't see that, whatever that might be. There is case law out there that if you ask for an RFP and it's material, and what if an individual, and I think this goes back to the Center for Sustainable Shale, what if a company thought that that was a requirement, that you had to be a member of that, and they didn't bid because they didn't meet the RFP criteria? So if they didn't meet that, and now you say, well, we're going to let the other bidders ignore the criteria, or maybe they have complied with it, I don't know. But that's why RFPs are set. So John does a lot more with this board than I do, so you probably speak to this better than I.
I think the number one rule is being informed, right? And if you can't be informed, then you can't make an educated decision. And on top of that, in this particular aspect, what you're talking about, be informed, that applies to if I'm buying a truck off a piggyback contract, right? I want to be informed, I want to know the process is taken, that there's a state contract and I'm buying it. But that rule applies at a much heightened level here because of the fact that you are dealing with an asset, and you have a Pennsylvania constitutional provision that says that you are a fiduciary of that asset, you have a trustee responsibility, and that trustee responsibility is not just for you, but for generations to come. So I think if you would want to know if the rules were followed and when you were going out and buying a street sweeper, I think you would probably want to know if the rules were followed if you were going to go out and drill the cars.
I have been very disappointed at the committee process and the individuals who came to stand before us to testify, and that I feel it was very one-sided. We had county employees, we had industry representatives, subcontractors subcontractors representative. We did not, the only outside people we had that is the DEP and, does our due, like, I asked for the people that are here tonight to be put on agenda for an official committee meeting. I asked, and because my colleagues haven't heard your testimony, everyone's testimony tonight, have they done their due diligence? I know it's a hard question,
Yeah,
but
and-
it's like they have only heard the positive side.
You know, and I understand your question too, and it's probably best I don't speak to it because
Okay.
that's something they're gonna have to decide for themselves.
Okay.
Maybe with their counsel as to, did we check all the boxes?
Okay.
Okay?
Well, thank you very much. I think we're going to take a 5-minute break, and then Dr. Pitt and his friend, and